On the record in the matter of the people of the state of Michigan versus Sergio Archer, file number 24-00979, counsel here.
Prosecution people appearing to serve the Michigan Court Rule 8.120 with Abigail Wilson as my supervisor.
Permission to practice granted.
Assistant Public Defender John Lee appearing on behalf of Sergio Archer.
Sergio Archer present.
He is not.
Have you had contact with him?
Have not. I have called, I have emailed, but I have not received any response.
Issue of bench warrant. With remand.
I'm sorry.
With remand, yes, thank you. We're all set on that one. On the record in the matter of the people of the state of Michigan versus Cameron Johnson, file numbers 24-00912. Counsel here. Can you speak up, please?
Prosecution people.
Jacob Riley on behalf of Mr. Johnson.
Cameron Johnson is just, they put the name in different in the system. Also, file number 24-01632, I had to confirm because they have the name differently on the docket. If you had contact.
Attempted contact, I did not do that.
I should make sure on forfeiture. On the record in the matter of the people of the state of Michigan versus Jasmine Kolak, file number 24-00010, counsel clear.
Prosecution people.
Assistant Public Defender John Lee on behalf of Jasmine Kowal.
Right. Yes.
No.
Johnson? Yes, yes. Okay, I'll share bench warrant for forfeiture. We have communication.
All that we mailed, we have not been able to establish contact.
On the record in the matter of the people of the state of Michigan versus Jalma Moore, file number 24-01132, counsel appearance.
Prosecution people.
Jacob Riley on behalf of Ms. Moore.
Okay, Ms. Moore is present.
Yes, sir.
Today is the date and the time that was set for a final pretrial. How are you, Ms. Moore? I'm well, thank you. Do you have necessary witnesses here?
No, Your Honor, the victim has not appeared today, even though I believe she was subpoenaed and I believe she received that subpoena. So you would expect a motion to dismiss.
Counsel?
Defense request dismissal.
Case is dismissed without prejudice. They do have the right to reissue the charge against you, okay? We'll get you a copy of the dismissal in just a moment. Do you have any questions for the court?
Yes, ma'am. I have been trying to get a job for a while and this has stopped me from getting it. So today, will it make it where it won't be here for them?
We're gonna get you a copy of your dismissal, so
Okay.
that helps clear up any issues.
Thank you.
Any other questions, ma'am?
No.
Okay, thank you.
Besides, your hair is beautiful.
Thank you. All you want is you can get her a copy when you get a chance. Record in the matter of the people of the state of Michigan versus Aria Parker, file number 24-00836. Council appearance, please.
Council Chukis for the people.
Assistant Public Defender John Lee appearing on behalf of Ari Parker, who is in the courtroom and standing to my right.
How are you, Ms. Parker? Well, thank you. Today's date and the time set for final pretrial. Yeah, necessary witnesses here.
We do not have our victim here, Your Honor, which I believe the victim was subpoenaed, but has not appeared, and we have not been able to make contact with the victim as of yesterday.
It must be summer, like nobody's coming to court.
It is 4th of July week.
So no one's coming to, you don't know where the defendants are, you don't know where victims are. How do you want to proceed, Mr. Lee?
The defense will make a motion to dismiss you.
Motion to dismiss is granted, it is granted without prejudice, so that means that they have the right to issue the charge against you, okay?
Okay.
We'll get you a copy of your dismissal. Do you have any questions for the court?
No, ma'am.
Okay, any additional matters for the record?
Nothing to be, Your Honor.
Nothing for the defense.
You're all set. On the record in the matter of the people of the state of Michigan versus Gabriel Yates, file number 18-00758, council appearance.
Bill Wilson for the people of Michigan.
Jacob Brilliant being executed.
Date and time set for final pretrial. Do we have necessary witnesses here?
Thank you, Your Honor. The complaining witness is not here in this matter. However, the people do have explanation. The people were in contact with the complaining witness's grandmother, who informed us that she had to go to a facility in California for a bit for some treatment. She is still willing to participate. She is still on board. The people would ask for a little bit of grace here. This is a 2018 case. It is rather old because of the defendant's prior failures to appear. So I believe an adjournment in this matter is appropriate.
Had to go to a facility in California, you said?
That is correct.
And does the people have any information as to a timeline as when
30 days?
She said at least 30 to 45 days.
before she's back in Michigan? Or
Correct.
he or she's back in Michigan? Okay, counsel.
Your Honor, defense respectfully request dismissal at this time, understanding that would be without prejudice. And if the alleged victim on this case wants to participate, the prosecution will have the option of refiling within the statute of limitations.
Motion to dismiss is denied. This matter has been set for trial and the defendant failed to appear. So
You too.
here we are in 2024 with a 2018 case and someone who would be here but for the fact that they are getting some treatment of some sort. It's not in the interest of judicial economy to dismiss this just for them to reissue it before she makes it home. And she has to be rearranged. So with that being stated, the final pretrial will be reset out to 60 days for now. And then the prosecution can let us know once they get confirmation closer to that time before the date, if it needs to be changed so that we don't make Ms. Yates come here for no reason.
Understood, Your Honor. Thank you.
September 3rd. Do you have any questions? I can't hear a head shake.
No.
Thank you. Any additional matters for the record?
Not for the people, thank you.
No, Your Honor.
Thank you. The record in the matter of the people of the state of Michigan versus Michelle Wilbur. File number is further here. The attorney here?
I saw Mr. Green.
Mr. Green, yes.
He.
Oh,
Well, he
maybe
went
we
down
need
to
to go
speak with
talk.
her.
Yeah.
Got it, sounds good. On the record in the matter of the people of the state of Michigan versus Alexander Marion, file number 24-01408.
Seek Chica's with you, Your Honor.
Assistant Public Defender John Lee appearing on behalf of Alexander Marion, who joins us via Zoom from the Clinton County Jail.
Alexander Marion, can you hear us? Mr. Marion, can you hear us? Because we can't hear you.
Yes, Your Honor.
Very good. Okay, today's the date and time set for pretrial and a retail fraud second degree. Was there an offer on this?
There is, I believe we're still working out a global resolution because there are several files at this time, across both, misdemeanor and felony, so I believe. Andy? So we're looking to set it out. Pending that resolution. Three weeks. And he's in MPS.
I'm sorry.
Never mind.
5:30 at 10. July 30th at 10. Do you have any questions for the court, Mr. Marion?
No, Your Honor.
Any additional matters for the record, counsel?
Not for the people.
Nothing for the defense, thank you.
Thank you, you're all set. On the record in the matter of the people of the state of Michigan versus Bradley Cross, file number 20-01413. Counsel appearance.
Seek Chica's for people.
Yeah.
Are you representing Mr. Cross?
Yeah, Jacob Riley on behalf of Randall Cross.
I don't see Bradley Cross present. Have you had contact with him?
I have not, I have attempted contact with them.
Okay, I'll show thank you on forfeiture. On the record in the matter of the people of the state of Michigan versus Cody Carr, file number 23-03462. Counsel appearance.
I don't believe Ms. Robinson is here. This is a forensic review, I believe, on a felony file, if I'm not
We don't have
mistaken.
any. This is old, I think. That's
No,
new.
got one yesterday. I think it was that one.
This is what we got yesterday?
The envelope.
There it is. And Mr. Harrison.
I don't believe so. I believe he would be on college.
Okay. For appointment. I got issue now. On the record in the matter of the people of the state of Michigan versus Amy Lynn Lischek, file number 24-01356. Council appearance.
Yes, the chief is for the people.
Jacob Rowley on behalf of Ms. Litchi.
Okay, Ms. Lischke is present via Zoom. Today's the date and time set for a pretrial, one count of domestic violence. Was there an offer on this?
Yes, Your Honor, there has been an offer. The offer was that the defendant plead guilty to one count of domestic violence with no objection to 769 or A if eligible.
And then after discussing that, my client, Your Honor, she's requesting final pretrial adjournments.
July 30th at 8. Final pretrial is July 30th at 8 a.m. in person at the court. Jury trial is August 27th at 8. August 27th at 8 a.m. for jury trial in person at the court. Do you have any questions today?
No, Your Honor.
Okay, we'll see you in person on July 30th. Any additional matters for the record, counsel?
Not from people.
Oh, you're right.
You're all set, ma'am.
Thank you.
No problem. We can go and get Mr. Green's client in custody, or are they he's downstairs, right?
I think
Okay. Mr. Green's right here.
Oh, he's back.
His client
Oh,
downstairs. We
yeah.
can bring him up. Or her up. Okay, on the record in the matter of the people of the state of Michigan versus James Leroy Seaton, file number 23-03178. Council appearance.
Abigail Wilson for people.
Edward Zane on behalf of the defendant, appearing via Zoom.
And your client, I believe, is present. Is he standing up? In your
Yes,
office?
Your Honor, that's him. He is. He's under my
Oh.
name at my office. My staff's there to support him, but that is Mr. Seaton.
Okay, very good. Today was the date and time set for a sentencing. I do have a pre-sentence report with a recommendation. The report was prepared back on June 27th. Did you get a copy of that, counsel?
Yes, Your Honor. Yes, Your Honor. Defense has the opportunity to receive and review that report. No additions, corrections, or deletions.
You can make allocation.
Thank you, Your Honor. I think, just a wonderful client. He's 30 years at the Boys and Girls Club of Michigan. He is somebody who has dedicated his life to public service. He is somebody who will be able to assist and deter others in the future from committing these type of offenses. He has taken advantage. Now, just to put this into context, this was April of 23, I believe, was the offense. Over the past year, he's used his time extremely productively. He got involved with Dr. Smith for an evaluation. The court has a copy of it. He's completed the highway safety and MAD impact panel. He's been educated both on the social and scientific aspects of drinking and how it relates to driving. He is definitely impacted by that panel. He's taken those lessons and been able to put those forth in his work. In his role over the past 30 years, most recently, he was voted on a national level Mr. Dependable. On a local level, he was the people's champion. A Myers organization had put forth through Big Sisters, Big Brothers program. This award where he was nominated and recognized for his service to the community. So he doesn't fall short on the ability to deter others and be safe in the community, as exhibited by his past year and a half conduct on bond. He's, I think, achieved the rehabilitative goals over this past year and a half as outlined in the evaluation. He has, as a part of his Christian faith, has been involved with his church and with his pastor to develop a healthier relationship for counseling and the therapeutic aspects of life that may have driven him to consume alcohol. He has also some significant medical conditions that I think contributed to the nature of the offense. With that being said, I look at the sentencing factors and I ask the court to consider whether or not we've met those rehabilitative goals and that the 6 months probation is at this point, a year and a couple months later, necessary to achieve any further rehabilitative purpose. In addition, I think the punishment, his time in jail, the financial consequences. I note that there's, I think, $766 in cost recovery from LPD alone. Those are impactful to him. Those are a punishment to him, again, as well as his time. Overall, I think we've achieved that sentencing factor. I think a more rehabilitated, punished individual able to deter others with access to the community is somebody we can rely on to not commit offenses in the future. He has achieved those goals of rehabilitation, I believe, as based on the evaluation and his course of conduct with the evidence provided to the court. So for that purpose, I'd ask the court, in your discretion, Your Honor, whether or not you think additional supervision is necessary or if it's just, kind of punitive at that point. Other than that, I rely on Your Honor's experience and ask you to sentence accordingly.
Were you seeking to make a statement?
I am briefly, Your Honor. First, Mr. Zaney is correct. There is no WI cost recovery, and I do have a pink sheet if I can approach.
You said there is none?
It is done, yes. It's in the amount of $765
Here, yeah.
and 36 cents.
I don't know that we necessarily need a pink sheet for
No.
OWI cost recovery.
Okay. And as to sentencing, I understand that Mr. Seaton has made some tremendous strides, it sounds like, on his own, and I applaud him for that. I am concerned about a fines and costs sentencing here. It appears that back in 2012, he was convicted of an OWI and sentenced to fines and costs. So I'm a little concerned that that's not going to work for him in this matter. I think a term of some kind of probation, some kind of supervision would be appropriate in this matter. But ultimately, obviously, it's at the court's discretion. That's all I wanted to say.
Okay, I've read the sentence report, reviewed his criminal and driving history, and I can appreciate that he's taking some measures to try to address the rehabilitative aspect of the case that's before us. I see in the file a copy of his certificate from the Highway Safety Seminar dated November 19th, 2023. And I also see a certificate of completion from MAD Impact that's dated, completed January 25th, 2024. This matter allegedly occurring on or about, well, having occurred on or about April of 2023, and he being arraigned in this matter in October. So since the time of arraignment, he's taken some steps to address the underlying issue. The information before the court is that the defendant, his assessment was having him diagnosed as having an alcohol intoxication use disorder. And so these things would have been appropriate. And I think some of the other things that he's doing with his time, that being, whatever he's doing with his Christian accountability group and Bible study or other things that help keep him centered and focused, are all positive reinforcements. I think that he does, however, need some supervision. This is not his first offense. He's had an OWI before, and he did only get fines and costs. I even see on his driving record where there was at least a citation given. It states here, 2002, Adrian 2A District Court, that there was an unlawful bodily content combined operating under influence back then. So this is not his second occurrence with law enforcement relative to operating while intoxicated. I don't know if he got a conviction for that 2002. I don't see that, but I know this is not his second conviction for operating while intoxicated. So I'm glad that he took his attorney's advice to go and get and be proactive about following up on those on that programming, but he is going to be placed on a term of supervision because we need to determine whether or not some additional resources may be needed to help ensure his long-term success. What we don't want to see is in the next 8 to 10 years, you're back here again for an alcohol-related offense. We love to see and hear that you are fully employed and that you are a public servant and that you're engaged in your spiritual life. But we also love to see that you're no longer drinking and driving. And so the court will adopt the recommendation. I find it to be appropriate. You will be sentenced to a term of 6 months of probation. You will report via Zoom. While on probation, you have the following conditions. You're not to engage in any assaultive or threatening behavior. You're not to use, purchase, or possess firearms, ammunition, or weapons of any kind. You're not to use or possess any alcohol, marijuana, or controlled substance, and you will be required to submit to random preliminary testing and/or your analysis testing, and you're responsible for the cost of that. Do you have any questions about that at this time?
No, Your Honor.
Okay. You would have otherwise been ordered to complete the MAD impact panel, but you provide evidence of that. I'll note that on my order. You'll maintain your employment and provide verification of that to probation. While on probation, there is a $30 per month oversight fee that you're responsible for. So 6 months of probation, if you do 6 months, will amount to $180. There's a $75 crime victim rights fee that must be assessed. A $50 state minimum cost that must be assessed. You owe the Lansing Police Department OWI cost recovery. All right, it's in the file, thank you.
Oh, perfect.
In the amount of $765.35. I'm gonna waive discretionary fines and costs at this time. And then there is prosecutor recovery of $120. Total of $1,190.35. You'll make monthly payments on it, okay?
Okay, Your Honor.
Lastly, there's an advice of rights as to probation. It indicates that you've been placed on a term of probation before the 54A District Court. And based on the charge that you are being sentenced on, you do have the right to request early discharge from probation. You can make that request once you've completed half of the original term, which would be once you complete 3 months, as long as you have not had any violations within that 3 months, okay?
Yes, Your Honor.
In order to make that request, you would file a notice regarding eligibility for early discharge from probation. It's called the MC 512 form, which is on the court's website, or you can get the form from your probation officer. You'll complete that form, file that form with the court, and a copy needs to be filed on the prosecutor's office. The prosecutor has 14 days from receipt of that to file any written objections. If I set the matter for a hearing, you have the right to hire an attorney to represent you. You would not have the right to have a representation by the public defender's office for any hearing for early termination or discharge of probation to date, I've never held a hearing for any request. Your probation officer also has the right to make that request on your behalf if they believe you're eligible for early discharge. Do you have any questions about that, sir?
No, Your Honor.
You'll be in contact with probation because they're gonna go over my judgment of sentence order for you to review and sign and begin your probation status, okay?
When do I have to,
Yes, sir.
when do I have to report to the probation officer?
You should check in with them within the next 48 hours. Just give them a phone call. You don't need to come in person. And then that will make sure that they confirm your contact information and tell you when they'll have your order available for you to review, okay?
Okay, thank you, Your Honor.
No problem. Any additional matters for the record?
Not for the people, thank you.
None from defense, Your Honor. Thank you for your time today.
Thank you. You're all set. On the record in the matter of the people of the state of Michigan versus Michelle Lee Wilbur, file number is 22-01595. Council appearance.
Available for the people.
Good morning, I'm Vince McBath from the defendant, Michelle Wilbur, standing to my right.
Ms. Wilbur, how are you? Today's the date and time that was set for sentencing. I do have a pre-sentence report that was prepared back in April. You got a copy of that, counsel?
Yes, I do, Your Honor.
Okay.
We had an opportunity to review that this morning.
Make out.
Thank you, Your Honor. As a court can tell, the Ms. Wilbur's in jail outfit. She is currently serving a 6-month sentence in Eaton County for probation violation by Judge O'Neill. Because of some mitigating circumstances, after she's sentenced today, I'm going to be seeing if she can get an early release of jail time, because she's already done 10 weeks. As indicated in the report, she's very remorseful, very ashamed of herself about committing this crime. And I do know that she's reached out to me a number of times from jail, directly and through other people, that this has really been a learning lesson for her. She's never done this amount of jail time before. And the 10 weeks she has done has really had an impact on her. And so she's very apologetic. She wants to really get out so she can move on with her life. She's always been employed. Her latest employment was with Speedway, one I know across my office on Waverly Road. She also was employed at Speedway on West Saginaw. And they have indicated to her she will have a job when she does get out. One of her concerns, and one would ask Judge O'Neill for an early release, she is on disability, and it would be in jeopardy if she serves through August of this year. But she's indicated to me, if the court does decide, whatever the court does decide, she will follow the court's orders. She wants to be successful in probation. She realizes she has a problem. She developed a problem recently, as the court would note, with crystal meth. And so that, again, has been problematic for her. She wants to make sure that does not happen again. So we'd ask the court to fashion an appropriate sentence to recognize all of the issues that she faces. Thank you, Your Honor.
So she's currently in custody on a 6-month sentence.
Correct.
And you're reaching out to the judge to see if it can be shortened because she's done about 2.5 months.
Correct. I have broached it with when I was out there a couple of times with Judge O'Neill. She's open to hear, especially after what happens today.
We know that the judge has the authority to change a sentence after it's issued. Because once your sentence is jail, I think they can go back and change that.
We're going to make a shot at it, Your Honor, because of some of the things I've cited.
I don't see why or how I can reasonably put her on probation under these circumstances if she's going to be in custody. That's because I don't believe that the court has the authority to go in and alter their sentence once that order is in there to reduce jail time. I think though she might be able to be released maybe on GPS tether or something like that, but I don't think that she can pretty much like you're jailed at home. I don't know that that is gonna even happen. I would have, in this particular instance, given her credit time served, but she had PR bond. So I can't even give her that. So in that case, she's gonna be sentenced to fines and costs. I don't have a judgment form here. There's a $75 crime victim rights fee, plus a $50 state minimum cost. The fine is gonna be $200. How do you intend to make payments on that, ma'am?
I can, as soon as I'm able to get out, I can start making payments.
So that may not be for another 4 months. I'll set it for show cause hearing in 90 days, so you'll see where she is. Okay. October 8th. At what time? 9:15. At 9:15. Any questions, ma'am? Any additional matters for the record, counsel?
No, people.
Nothing for the defense, Your Honor.
We're all set. Jeremiah Williams has been on here for a while, but he's not started his audio.
This is the Easter one. It's got to be 10, so he's got a bit.
Do you have Mr. Lee?
I have Mr. Trevino, Your Honor, Brett Trevino.
Sir Williams, can you hear us? Okay, we're just waiting for your turn. Okay, on the record in the matter of the people of the state of Michigan versus Brenton Macy Trevino, file number 24-01701, counsel appearance.
Cassidy, could you just for people?
Assistant Public Defender John Lee on behalf of Brett Macy Trevino.
Okay, today is the date set for pretrial, 1 count of domestic violence. How are we proceeding?
I don't believe there's been an offer made yet, and we do not have one at this time, I believe, because we have not been able to make contact with the victim recently to discuss that.
Counsel?
Your Honor, we'd like to set the matter for a final pre-trial.
Pretrial July 30th. Jury trial August 27th. Okay, final pretrial in person at the court. It's gonna be July 30th at 8 o'clock in the morning, and your jury trial August 27th at 8 o'clock in the morning. Have any questions, sir? Any additional matters for the record, counsel?
Not people.
Nothing for the defense, Your Honor.
Okay, we'll get you a copy of your notice to appear. Mr. Easterly?
Are you done?
Mr. Easterly,
Oh, he's not.
Easterly, not Mr. Lee.
Good morning, Your Honor.
Good morning. Your client, Jeremiah Williams is ready. Are you ready to proceed on that matter?
I am, Your Honor.
Okay, on the record in the matter of the people of the state of Michigan versus Jeremiah Williams, file number is 24-01576. Council appearance.
Cassidy Chicas for the people, Your Honor.
Good morning, Your Honor. Robert Easterly on behalf of the defendant, Mr. Jeremiah Williams. We are both present via Zoom, and he waives his right to any in-person appearance.
The date and time that was scheduled for a pre-trial one count of domestic violence. Was there an offer on this?
I have not been able to make recent contact with him to discuss the offer, therefore there is not yet an offer in this.
All right, counsel, how do you want to proceed?
I'm sorry, Judge, I could not hear what counsel
The
said.
prosecution has yet to be able to make contact with the complaining witness. How did you want to proceed for next steps?
Oh, thank you. We're prepared to advance to final pretrial.
July 30th at 8 work for you?
It does. Thank you, Judge.
Okay, that's in person at the court and jury trial. August 27th at 8 work for you?
It does. Thank you.
Okay. Do you have any questions for the court, Mr. Williams?
You have to unmute yourself, sir.
Say no, I do not.
Okay, any additional matters for the record, counsel?
Not for the people.
Not for the defense, Judge. Thank you.
Thank you, you're all set. Mr. Owens was here earlier, but he left. Does he have an attorney?
Mr. Williams, I'll give you a call.
I don't see one on my docket.
That was
Yeah,
Probably not.
I had a public defender. He's probably not there right
Oh,
now.
yeah.
or no, maybe it's not. It's
I
not.
represent Mr. Owens.
Oh, you might, do you need to speak to him?
No,
Okay, your public defender is here, Mr. Owens.
Okay.
On the record in the matter of the people of the state of Michigan versus Philip Owens, file number is 24-01736. Council can have your appearance.
Cassidy Chicas for the people, Your Honor.
Jacob Rowling on behalf of Mr. Owens.
Okay. Today is the date and time set for pre-trial for malicious destruction of property. I'm trying to see why we don't have your name on our docket. Mr. Owens. You may not have gotten an appearance from you yet. Let's see, was there an offer on this?
There has not been an offer made, Your Honor.
Mr. Raleigh, how do you want to proceed?
At this time, we would request that this matter be set for final pretrial.
Final pretrial is going to be July 30th, in person at the court. Jury trial set is going to be scheduled for August 27, also in person at the court. Mr. Owens, do you have any questions?
So hold on. I'm having court on August what?
Your next court date is going to be July 30th, and you must appear in person. And then the matter is scheduled for jury trial, August 27, in person at the court.
So what is going on today?
Today was the day that was set for a pretrial. That's typically where you discuss if there's going to be an offer or a resolution short of what you were originally charged. The prosecution just stated on the record that there has been no offer to reduce this charge. So that means that your options would be to plead guilty to malicious destruction of property or to execute your right to a trial. And so your attorney indicated that we wanted to proceed to a final pretrial because there's been no offer. That final pretrial will determine whether or not we should go to trial or not.
Okay, so we're just not fighting for not guilty at all.
That's exactly what you're doing, actually. But if you're not guilty, that means if you plead not guilty, you gotta go all the way through to a trial unless one of two things can happen. The prosecution can decide that this is in the interest of justice to dismiss the case short of a trial, or at the final pretrial, which is your next court date, the witness is required to appear in person. If there's no witness, or if they're not engaged with the prosecution's office, your attorney will likely make a motion to have the case dismissed against you.
Okay, because I was gonna say I have multiple witnesses, and
I
I have.
recognize, I'm gonna stop you.
Mr. Owens,
This is a final pretrial, and those conversations that you're having need to be between you and your attorney in confidence, and you all will formulate your defense in that manner. But your attorney has maintained that you have you're pleading not guilty or maintaining your innocence, okay? And that's why he
Okay.
has requested the final pretrial.
Okay, because I just want to know what to tell my parole officer.
So we can talk later, just you and me privately, we don't have to discuss that on the record.
Okay, can you call me?
Okay, you're all set, sir.
All right.
Who's on the device PCD P63L? What's your name, sir? I'm sorry, I couldn't hear you.
Janet.
Thank you. Is he our attorney?
Yes, public defender's office is representing Mr.
You don't have a hearing, I don't believe. I'm sorry?
Could I get him on, speak with him on Zoom?
Yeah, there's someone in the jail though, that must be Michael Thomas. Who's representing Michael Thomas?
That's me.
Okay. You can log in, Mr. Lee.
Okay, thank you.
Hello?
You can be seated. We got everybody here on the record in the matters of the people of the state of Michigan versus Stanley Brock, Timothy King, and Kent Vanderwood. File numbers 23-02213, 23-02216, and 23-02224. Council, may I have your appearances, please?
Good morning, Your Honor. Assistant Attorney General Kayla Crino appearing on behalf of the people.
Morning, Judge Derek Wilczynski on behalf of the defendant, Stanley Grote.
Morning, Your Honor. Jacob Perone on behalf of Timothy King.
Good morning, Your Honor. Brian Lennon and Michael Boville on behalf of Kent Vanderwood.
Okay, very good. Today was the date that was set for a hearing, really just because we need to set a date for the preliminary examination. So I needed to align everyone's schedule and make sure my schedule was adequately open for what I believe would need 7 business days minimal. Maybe we can do it at 6 since we don't have as many objections and cross objections because it's only 3 instead of 6. So, but a minimum of a week of worth of time consecutively to get this examination completed. And so, let's see here. What is our, what one we're scheduling into right now? We're currently scheduling into September. And so if I can have your jury schedules for the month of September and October, as well as any important other appearances that would prohibit you from being able to be in this court for 5 consecutive business days.
Your Honor, in terms of October conflicts, the people will have to confer with co-counsel, but we can do that promptly and inform the court of any of those days. In terms of September, the only conflict I'm aware of at this time is September 5th and 6th.
Okay, and I don't need it right now. You all can actually send those via email to my judicial assistant. And then that way that allows me to look at my schedule and we work whatever we need. Let me have you send me actually September, October, and November, because it could get challenging trying to work with all these different professional schedules. That'll give us enough time to make sure we block off that time and that it's not conflicting with any other court dates that you have and trial dates.
Thank you, Your Honor. We'll get that to you promptly.
Sounds good, Judge.
Sounds good. Is there any other issues or questions the defense counsel or the prosecution wants to address today?
Nothing on behalf of the people today. Thank you, Your Honor.
Nothing on behalf of Mr. Grote.
Nothing on behalf of Mr. King.
And nothing on behalf of Mr. Vanderwood. Thank you, Your Honor.
Thank you. You're all set.
Thank you, Judge.
Thank you.
Thank you, Your Honor. Have a good day.
Same to you. Okay. Did we see the motion for set-aside conviction? I haven't seen them. Mr. King, you're free to go.
Jeremiah Williams.
Let's see, Michael Thomas, we're ready on him.
I believe so.
On the record in the matter of the people of the state of Michigan versus Michael Daniel Thomas, file number is 23-01315. Council appearance.
Abigail Wilson for the people.
Jacob Raleigh on behalf of Mr. Thomas.
Okay, today was the date and time that was scheduled for a pretrial police officer assault is the charge. How are we proceeding?
Thank you, Your Honor. I believe that this is gonna be set for a final pretrial and corresponding jury trial. There has been no offered relayed at this time.
Okay, I don't know that we need a final pretrial because I don't make officers come for final
Okay.
pretrial. So I can set it for a jury trial.
That
Let's
works.
see. I'll be 6. August 6th at 8 o'clock in the morning. I see he was remanded back on June 4th on this.
That is correct, Your Honor. I believe Mr. Riley has a motion to that.
Okay, you can address the court.
Yes, Your Honor, I'm certainly requesting reinstatement of Mr. Thomas's bond. He has custody of the case since June, if I'm not mistaken. But you want to know that while this case was pending and was in warrant status, Mr. Thomas was also on probation to the circuit court. And in fact, he learned of the warrant from his probation officer and turned himself in when he learned that there was a warrant. So I certainly think he intends to come to court and comply with the court's orders going forward. To my knowledge, there have been no violations on his probation. So certainly I would request that he be allowed to enjoy his freedom now in his trial date.
If he wants to enjoy his freedom, he needs to remember his court dates. We don't babysit people. He had a 25,000 cash surety bond is what it looks like he originally had. You would think with something that high, you would keep up with your court dates. No?
I believe it was a PR bond, Your Honor.
It says cash surety on here. I'm just reading.
I believe he did post a $25,000 bond.
Cash surety. Relatively high bond, but it probably took into consideration the charge, and it noted here that he was on bond already for 3 felony assaults and harboring a fugitive. So if you're gonna have the opportunity to be released on pretrial bond, then you need to keep up with your court dates, and returning saying I didn't know about it is not sufficient enough, because you should know about it because you were arraigned and you were given a court date. Reinstate your bond. I expect you to be at your next court date. When is that, Mr. Thomas?
Your Honor, I believe I heard you say August 6th.
That's correct, at 8 o'clock in the morning in person, okay?
Okay.
Okay, you shouldn't be carrying on with your life just acting like you don't have a pending case. If you forget what the date is, you go and find out. You have an attorney, he should have your number. You all should be meeting before them because it's set for a trial. I have a number for you ending in 8096, and there's another number ending in 5328. Are those still accurate?
You said say, I'm sorry, say that one more time. 85. Say that one more time.
What's your phone number?
Okay, so my number is 517 303 8096 or 96. Yeah, 96.
That's what we have. Yep.
Okay, and then another number is that I can be reached at is 517 303 8502. And then if possible, my father number is 517 377 5328.
Okay, we have 3 numbers for you, so no reason why your attorney won't be able to make contact with you to make sure you know to appear in person and dressed appropriately, ready to proceed for your trial. Do you have any questions about your bond conditions?
Is it a PR?
I'm reinstating your previous bond.
Okay, no more questions then.
Any additional matters for the record?
Your Honor, I don't have his previous bond conditions in front of me, but I'm wondering if, given the prior failure to appear, a GPS for tracking purposes might be appropriate.
You said he's currently on probation.
That's correct.
And he's been compliant with that probation?
Yes, at least to my knowledge, there's not been any alleged violations.
He's already under court supervision, and it sounds like that's the reason why he was notified that he had this warrant and he turned himself in. I don't think GPS tether is necessary. I think he needs to be responsible and put his court dates in a calendar so he knows when to appear. So you're all set for today, Mr. Thomas.
Thank you again so much.
You're welcome. I don't know who this must be Mr. Lee's client. He might, I think he keeps logging out and logging back in. I know what happened to people with the motion, but I guess they don't want it anymore. So, Mr. McGee?
Yes, ma'am.
You have a lot of noise coming from your device. What is that all about?
Maybe just the echo.
Okay, well, we don't want to hear it. So if your device can't work in virtual court, you appear in person.
Well, it was for me.
We don't know what you're saying.
Here. Hello.
I actually meant to mute him, not me. I'm going to mute your device. On the record in the matter of the people of the state of Michigan versus Terrence McGee, file number 24-01625, counsel appearance.
Can I see the chief is for the people?
Assistant Public Defender John Lee on behalf of Terrence McGee.
Oh, okay, today was the date set for a pretrial on a domestic violence. How are we proceeding?
I do not believe that there has been an offer made in this matter, so I would expect the defense to request to set this for final trial.
That is accurate. Yeah.
Pretrial July 30th at 8. Final pretrial for you, Mr. McGee, is going to be July 30th, 8 o'clock in the morning. You must appear in person at the court. Jury trial September 3rd. Jury trial will be September 3rd at 8 a.m. in person at the court. Any additional matters for the record, counsel?
Nothing to the defense. Thank you.
Thank you. You're all set, Mr. McGee. Did that one. Did that one. There's that.